You're with us. Ready?
Let's do it.
Good afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and it's my honor to welcome you to our virtual platform to today's lecture. The Society was founded in 1974 by then Chief Justice Warren Burger to improve public understanding about the Supreme Court, the Constitution, and the judiciary. Among the elements the Society has utilized in our outreach are our lectures on the court's history and its justices. During the pandemic, we began utilizing Zoom for our lectures, and we plan to continue these virtual lectures as it has expanded our outreach enormously, even as we return to in-person programming as well. If you've missed an earlier program, please visit the Society's YouTube page to watch them. I think you will enjoy them. In addition to our loyal Supreme Court Historical Society members, we are joined today by members of the SEC Historical Society, the Treasury Historical Association, and the Society for the History of the Federal Government. Thank you all for joining us. Our speakers this afternoon are Adam Pritchard and Robert Thompson. Adam is the Francis and George Gestos Professor of Law at the University of Michigan School of Law, where he teaches corporate and securities law. He received his JD from the University of Virginia, and he clerked for a dear friend of mine, J. Harvey Wilkinson, on the Court of Appeals for the Fourth Circuit. He served as a Bristow Fellow in the Office of the Solicitor General at the U.S. Department of Justice. And after working in private practice, Professor Pritchard served as Senior Counsel in the Office of General Counsel of the SEC, where he wrote appellate briefs and studied the effect of recent reforms in the areas of securities fraud litigation. He received the SEC's Law and Policy Award for his work in the United States versus O'Hagan, in which the Supreme Court upheld the misappropriation theory of insider trading. Professor Robert Thompson is the Peter Weidenbrook Professor of Business Law at Georgetown University Law Center, where he teaches courses in the corporate and securities area, including mergers and limited liability. He is also a graduate of the University of Virginia School of Law. He has authored or co-authored case books on corporations and on mergers, treatises on close corporations and oppression of minority shareholders and LLC members. And he's published more than 50 articles. Professor Thompson has testified before committees of Congress, a state legislature, and the New York Stock Exchange. He has served since 1991 as editor of the Corporate Practice Commentator, served as an advisor for the American Law Institute's Restatement, Third of Agency, and chaired 2 sections of the Association of American Law Schools. Together, they're the authors of the History of Securities Law in the Supreme Court. I'm going to hold up a copy of that book, and we'll do so at the end of our lecture today also. We encourage you to buy it. It's a fascinating history, and it examines how the Supreme Court has shaped securities law in our country. That work is the basis of their talk today. We are delighted they have joined us. As a reminder, we're going to be taking questions from our audience at the end of their discussion. And if you would please drop your questions into the Q&A box, we'll get to as many of those as we can in the hour that we have allotted for today's lecture. We will turn to those questions with about 45 minutes into the lecture. We'll see how it goes. We're anxious to hear them talk. I will get out of the way. And professors, the Society's virtual floor is now yours.
So good afternoon, and I'd like to thank Jim for doing the honors of hosting this session, and I'd like to thank the Historical Society for the invitation. We're very pleased to join you. We're going to talk for a bit but there's going to be time at the end, and we very much would be interested in hearing the questions from the participants. So this is a history. So we're going to start with the creation of the securities laws, beginning with the first 100 days of the New Deal. The Securities Act of 1933 was part of that first 100 days in the Roosevelt administration. But during Roosevelt's first 2 terms, 7 more statutes followed, regulating securities exchanges and public companies, public utilities, bankruptcy, and mutual funds. What these laws had in common was that they were part of a gigantic effort to impose social control over finance. So, Bob, I'm going to pose the first question to you. What is the most important takeaway from this origin story to understanding the role of the Supreme Court in securities law?
Well, the key observation that we came away with is the importance of the work of the justices before they got to the court and started making these decisions. Essentially, it's a prequel story. We want to talk about what they were doing before they got to the court. And what that was is that they were writing the statutes, they were getting Congress, helping Congress pass the statutes, and they were arguing the challenges to these statutes before what was often a hostile court. So the soon-to-be nominees, soon-to-be justices, were doing all these things on the front line. This fact shaped the securities laws for the next 30 years. Professor Felix Frankfurter is well known in this regard. He, from his perch at Harvard and with his proteges, Landis, Cohen, and Cochran, he, in a sense, wrote the 3 acts on Adams' prior slide that were passed during FDR's first term. The 2 justices that preceded Frankfurter, who appears at the 3 o'clock portion of the slide on your screen, Hugo Black had a key role in passing the Holding Company Act as a member of the Senate. Stanley Reed, he came second, had a key role because he was the Solicitor General, and he undertook the defense of these new acts when they were challenged in the courts. The 2 that followed those first 3, Bill Douglas had spent that time as 3rd chair of the SEC, running what was a very activist SEC in dealing with the New York Stock Exchange, bankruptcy, and holding company litigation. Frontline experience all. Robert Jackson was actually at Treasury during the first term, but he got pulled by FDR away from Treasury to basically help coordinate the litigation strategy that was going on as to this legislation that was being challenged across in New York and Baltimore and other places. He later became Attorney General and had a continuing role in the statutes. And when he went to the court, Frank Murphy followed his path as both Attorney General and then to the court. Wiley Rutledge was a professor of corporate and then what became securities law, and had written about these questions. So all in all, the bottom line is this is what made the impact for the origin story and the early history of securities law. Franklin Roosevelt filled 5 seats on the court over 29 months at the beginning of his second term, after 0 during the first term. Roosevelt eventually filled 8 seats of the 9 during his second and third term. All of them believed in social control over finance. They all were committed to the administrative state and reflected judicial deference to the administrative state. PUCA, the Public Utility Holding Company Act, was an early focus of this debate, and the Supreme Court weighed in on that. They also did other things like Chenery 2, a famous administrative law case, along with Chenery 1, showed them reaching out on insider trading. Clearly, their justices' personal involvement on being on the front line of writing the statutes and passing the statutes and defending the statutes before what was a hostile court before they got there, was the significant influence that we found in tracing the origins story. Adam, back to you.
So we think one of the most important takeaways from this formative period for the Supreme Court's interaction with securities law is Franklin Delano Roosevelt's overwhelming success in appointing justices who would be helpful to him in achieving his policy goals. So presidents who succeeded Roosevelt had less success from their own perspective in appointing justices. If you think about Dwight Eisenhower appointing Earl Warren and Bill Brennan, those justices did not play out quite as he had hoped. Why was Roosevelt so successful? We think that part of the answer is the prior advocacy positions that these justices had played as part of the Roosevelt administration served a bonding role to adhere them more closely to his policy goals. Roosevelt also had a litmus test for appointees to the court. None of the appointees, the 8 appointees that Roosevelt made, opposed his court packing plan, which was deeply controversial even among liberals at the time. Also, a number of them had personal connections to Roosevelt. So the picture with the reporters is Bill Douglas holding his first press conference at the SEC after Roosevelt made him chairman of the SEC. But in the evenings, Bill Douglas and Bob Jackson were playing poker with Roosevelt. Felix Frankfurter served an important role as an advisor to Roosevelt, both before and after his appointment to the court. And the final point that I'll make about why this was such a reliable court from Roosevelt's perspective, this was not a terminal job, or at least a number of the justices did not see their appointment to the Supreme Court as a terminal job. Conspicuously, Hugo Black and Bill Douglas angled for the vice presidential nomination in 1944. Murphy had been looking to be the nominee as president when he was attorney general before Roosevelt got rid of him by bumping him to the court, but no doubt retained political ambitions. All of that meant that the transformation of the Supreme Court that Roosevelt accomplished with his appointments played out with decisions that were much more to Roosevelt's liking than the decisions that he had encountered prior to 1937.
And Jackson too was rumored as part of a possible successor to Roosevelt before he decided to go for a third term. So there was lots of ambition around. As an aside to the last picture, that press conference, the SEC at the time was located. One of the things we found in doing this research with the different places the SEC was located over the time that we're covering. They were first until the war came. They were a block west of the White House on Pennsylvania Avenue, and then they got sent to Philadelphia, as many of you probably know, during the war. Didn't come back for several years after the war, and then there had been a series of locations nearer to the court. They've been within a few blocks of the court ever since. Our second question we thought we'd pose is that in any Supreme Court history, a key focus will be on the people, on the justices. So the question is, what does this research, what did we learn that you may not know about as to the people? So Adam, take that if you would.
So I started this historical research in connection with my work on the O'Hagan case. And one of the things that immediately came through as I was doing this research, and as Bob and I continued this research together, was the significant role that Lewis Powell played in the making of securities law during his time on the court from 1972 to 1987. Whereas Roosevelt's appointments of the New Deal justices had a very interventionist perspective on the role of securities law in the national economy, Lewis Powell, before he came to the court, had spent a lifetime as a corporate lawyer in private practice in Richmond. And he started out as a lawyer in 1933, just as the securities laws were being enacted by Congress, and cut his teeth doing public offerings in the 1930s, including knocking on doors at the SEC building at that time to try and get some guidance as to how you would actually do a registration statement under this new act. So Powell had respect for the SEC, but it is fair to say a measured respect accompanied by some skepticism. He thought the securities laws were useful, but he thought that the SEC had always sought to expand its reach, in this quote. And his skepticism of the SEC and his perception of its tendency to overreach led him to read the securities laws much more narrowly than they had been read in the nearly 40 years prior to his appointment. But he's 1 out of 9. What mattered was not just Powell's views, but his ability to bring other justices around to his views. He was not a dissenting voice in the field of securities laws. He was in the majority 40 of the 41 cases that he participated in during his time on the court. He wrote the majority opinion in 11 out of those 40 cases. And so what doing this research, investigating the justices' private papers, their communications with the other justices and their law clerks, and in Powell's case, he even dictated memos to himself while he was reading the briefs in the cases that his secretary, Sally, would transcribe, and they would be there in the files, providing an unvarnished view of what he thought of the cases. And you can see in the files that the justices kept for themselves, you could see Powell preparing memos in preparation for the court's weekly conference, outlining the arguments that he thought were essential for the securities cases that were being decided, both in a bid to have the opinion assignment given to him, as demonstrated by his 11 opinions in the 40 cases, but also to persuade his fellow justices. Bob, your thoughts on this?
So 2 points about Powell. First, the difference between he and others that knew securities. Roosevelt, as mentioned before, had appointed 8 justices. That meant that the court had a majority of justices appointed by Democratic presidents up until just before Powell arrived. And then it flipped to majority by Republican presidents, where it's continued ever since. The key part we found is how Powell got to 5. He never had, because the Republican appointees included Warren and Brennan, Powell never had a natural majority of those that would favor the views that Adam has just disclosed. So he had to persuade in every important case that he wrote. He had to get to 5. He had to persuade someone such as White, and who had supported general enhancing opinions before then. He persuaded Marshall sometimes. He persuaded Blackmun sometimes. Powell got to 5 and often to 6 by persuading those who had taken a different view. And this is a recognition of his persuasive ability that came from both his expertise and his familiarity, but also the preparation that Adam talked about. The second point was Adams mentioned his 11 opinions. That was more than anybody else in securities throughout the entire history. And it compares to Frankfurter, who wrote 1. That tells you the difference it makes with personal qualities of persuasion. There was a quote we found that from Harry Blackmun after he had been outmaneuvered by Powell and found himself in the minority, as he often did. But he called Powell our corporate lawyer, that quote on the screen. And that tells you why Powell was so important during the time in which the court reversed itself as to securities. Beforehand, the enhanced view of securities had prevailed for decades. Once Powell got there, the restricted view prevailed in the next 23 cases in a row. It just made a dramatic difference. Adam, you want to go to the third question?
Yes. So we've been talking about Lewis Powell, and one area that we didn't discuss in connection with question 2 is insider trading, which Powell had a very significant influence. Talk a little bit about Powell's role in developing the Supreme Court's approach to insider trading jurisprudence.
So what we found about insider trading is that, at least in the modern term that students today understand it, insider trading did not show up at the court for almost 50 years. Powell's opinion in Chiarella, the first of those insider trading cases, is central to our story of the history and is consistent with Powell's general approach, as Adam has just described. But the historical context of how insider trading got to the court has some important complications. Insider trading was certainly around at the time of our origins story. If you go back to Ferdinand Pecora's famous hearings in early 1933 that set up the first 100 days as to securities, insider trading was a recurring concern of those hearings. So what did Congress do? It passed the mechanistic, ineffective Section 16B. And what did the Supreme Court do? It ignored the mechanistic, ineffective 16B for almost 35 years. The fiduciary duty, which is the intellectual foundation for modern insider trading law, at the time, for all of that period, didn't seem to have the room to police insider trading, at least in anonymous public markets. When Bill Carey came to chair the SEC in 1961, he had a different view, and he set about to change that. And during the 60s, the Second Circuit embraced that view in Texas Gulf Sulphur. But the Supreme Court held its distance for another dozen years. So the Supreme Court never entered the fray of today's insider trading until Chiarella in 1980. Powell was important. He was willing to support the innovative use of fiduciary duty as fraud, which otherwise caused him problems in Santa Fe and the other cases of the 70s. He was willing to entertain having insider trading as fraud, so long as there was a duty owed by an insider, such as an officer or director, to their fiduciary, who was the shareholder of that company to whom there was a fiduciary. The shareholder was the person that was the counterparty to the trade from whom the shares were bought. That would be fine for insider trading as in Powell's view, but it would not include Vincent Chiarella. Vincent Chiarella, whose picture is on the screen, was a printer at Pandic Press in New York. As he set the type, he deciphered the code for what was coming for takeovers and the money that could be made by buying them before the announcement occurred in the morning paper the following day. He made money and was the first person charged and then convicted of criminal violations for insider trading. When that case got to the court, it was not argued on the basis of Texas Gulf Sulphur. It was argued, it had been presented. There was also the misappropriation theory, which was courtesy of Frank Easterbrook, who was then Deputy Solicitor General at the Justice Department. The result was that but even though the misappropriation was before the court, in the surveys that Adams found and elsewhere, we found that five of the non-justices would have entertained misappropriation, but because it had arisen via the SG's office after the trial on the Second Circuit opinion, it had not been argued to the jury, and the court was not willing to put Vincent Chiarella in jail for a theory that was not argued to the court. So the holding in Chiarella is only that you can go to jail for insider trading if you have a duty to the person you trade with and not someone to whom you're a stranger, which was Chiarella. The result was, at that point, when the Supreme Court first got involved, insider trading has a narrow base to it. Now, in terms of a history point, the press of the day did not miss the key point. The New York Times story the next day highlighted that the Justice Department and the SEC would be continuing to bring cases based upon misappropriation, but it was not within what Powell had decided in Chiarella, and it did not come before the court for another till 1994, 14 years later, when the Supreme Court upheld misappropriation. Two of the non-justices from Chiarella remain on the court, and it got a majority that has expanded insider trading much beyond what Powell was willing to do.
So it's worth noting that the O'Hagan case, where the Supreme Court accepted the misappropriation theory, almost didn't happen, because it's not quite right to say that the misappropriation theory did not come back to the court before O'Hagan. It did come back to the court in the Carpenter case, which involved the herd on the street insider trading scandal at the Wall Street Journal. The court split 4-4 in that case on the securities fraud counts, so it did not issue an opinion on the misappropriation theory. In my research for the O'Hagan case, however, I found in Justice Marshall's files dissent from the denial of certiorari that Justice Powell had drafted that rejected the misappropriation theory as inconsistent with the opinion that he had written in Chiarella. If the court had addressed the misappropriation theory at that time, it's likely that they would have rejected it. But Justice Powell retired in between the grant of certiorari in the Carpenter case and the court's oral argument and decision in that case the following term. And because it took a long time to find a replacement for Justice Powell, there was an empty seat, and the misappropriation theory lived to see another day in the O'Hagan case. And by that time, there was no one to lead the charge against it in the way that Justice Powell might have done if he were still on the court. We skipped a little bit here, Bob.
Well, what do you want to bring in, Adam?
Well, let's go back a decade to the 1960s.
Well, that's certainly a less well-known era, but one where the Justice's papers also told us something we didn't necessarily expect. So tell us what the Warren Court looked like in securities law.
So the popular perception of the Warren Court is as an activist court in the areas of criminal procedure and constitutional law, but a lot less attention is paid to the court's role in securities law during that time. And the 60s court in securities law followed up a decade where there was not much happening in securities law, either at the Supreme Court, but also at the SEC. The SEC was underfunded and had a series of chairmen who were not interested in pushing any particular agenda. And we saw Bill Douglas expressing real skepticism of the SEC in the variable annuity life insurance case that was decided in 1959, and skepticism that it was really up to the task of regulating the securities markets. A big change comes when John Kennedy starts appointing new justices to the Supreme Court, who took a very different attitude to the interpretation of the securities laws. Arthur Goldberg here is on the left of this slide. His attitude towards his role as a Supreme Court justice was that the passive virtues of the judiciary were a vice. He came to the court wanting to get things done. And we see that in the Capital Gains Research Bureau case, which brought fiduciary duty theory into the interpretation of duties of disclosure under the securities law. And this was the product of a suggestion from Byron White, who is appointed also by Kennedy. And the new blood of Goldberg and White, combined with holdover justices with a liberal orientation, Black would serve throughout the 60s, and Douglas would serve until 1975, created a new coalition that was much more activist, not merely deferential to the SEC, but seeing the court's role as a partner in developing securities laws. The other significant development, a very free-willing interpretive style in the J.I. case decision, which unleashed implied private rights of action in combination with changes to class action rules in the Federal Rules of Civil Procedure in 1967, created the class action industrial complex in securities law that we know today. There was no federal incorporation statute adopted by Congress, but the 60s Supreme Court seemed to be creating a federal corporate law on its own motion. Bob?
So there was not much happening, as Adam said, at the Supreme Court or the SEC, but the Second Circuit was certainly active during the 50s and 60s. And just a word about that and capital gains. Capital gains came to the Supreme Court from the Second Circuit. At the Second Circuit, all of the justices, all of the judges on the Second Circuit had hewed to a strict privity kind of approach to fiduciary duty. They were very narrow in what could count as fraud. Once the Supreme Court acted in capital gains, the Second Circuit flipped. They became much more active, willing to engage in the implied private rights of action that Adams talked about, because of the influence, I think, of capital gains. So you can see Charles Clark, who was a Yale colleague of Douglas, had been appointed to the Second Circuit during the prior period, and made a real difference. This is when the Second Circuit became the mother court of securities law, as it's sometimes referred to. So even though the Supreme Court was the driving force, the Second Circuit did important implementing work, as in Texas Gulf Sulphur. So that brings us closer to the present. So we just thought we'd close with a question that focuses on what happened since then, and what does that tell us, if anything, about today. So Adam's gonna start with that.
So for this question, we think that the numbers tell an important story. You can see we've classified the opinions of the court from each era, pre-Powell, from 33 to 72, the Powell era from 72 to 87, and then a modern era starting after Powell's retirement. And the expansive to restrictive ratio, dramatically expansive in the first period, and then flipping to become consistently restrictive during the time that Powell was on the court. But when Powell goes, it falls into equipoise. Half the decisions are expansive, half the decisions are restrictive. We call this period the random walk, because there's no consistent theme in the Supreme Court's securities jurisprudence after Powell leaves the court. The justices from that time on have had no particular experience with the securities laws. So there's no driving force in any of the decisions. What emerges is a large number of cases that are pretty unimportant from the perspective of the securities laws, an inordinate number of statute of limitations cases, procedural cases involving class actions. The one exception would be the Basic versus Levinson case, which Harry Blackman wrote the opinion for immediately after Powell retired, which greatly expanded the reach of securities class actions, which kind of harkened back to the 60s expansive era. But since then, it's been back and forth with no particular direction. And so the theme of this last period, if there is any, is a court that is anxious to defer to Congress. The adoption of the Private Securities Litigation Reform Act in 1995, when Congress finally intervened to rein in the implied rights of action that the court had created. The court has treated that as a validation of the private right of action, has endeavored to interpret the PSLRA consistent with congressional intent. But when more fundamental questions have arisen, such as in the Halliburton case, in which the defendants asked for the Basic versus Levinson case to be overruled, the answer from the court is stare decisis, that this is a statutory interpretation question now, and we are going to defer to Congress. Congress changed things in the Private Securities Litigation Reform Act, but didn't make revolutionary changes, and we're not going to make revolutionary changes on our own. The other takeaway from this last period, Powell had a very significant influence, not only on the outcome of the securities cases, but also in the selection of the securities cases. On more than one occasion, he was prepared to write dissents from the denial of certiorari, which produced 4 justices who would be willing to hear the case. But Powell knew enough about the securities law to know which cases mattered. And the cases that were chosen had a significant impact on the law. after Powell's retirement, the Supreme Court is not great at choosing which cases to take up. So the only insider trading case the Supreme Court has taken up subsequent to the O'Hagan case in 1997 has been the Salmon case, which the Supreme Court said, you should apply Dirks. Dirks applies here, go with that. Goldman Sachs trying to figure out what should happen with the price impact defense that they created in the Halliburton 2 case. They were left saying, well, we're not sure what the Second Circuit did here, so we'll send it back to them to help them clarify. So the cases are not terribly significant. So here's another chart that explores more particularly the SEC's win-loss rate in the Supreme Court. Bob, do you want to say anything about this chart?
The one thing I would say is we've had 90 years of securities law at the Supreme Court. If you look at the 15 years of the Powell era, that was half of the cases. 1/3 that was, in other words, just overrepresented in that case, and very little since then. And the second point was the early periods were very much this chart tells you the SEC's participation rate and what its win-loss rate was. And what you see is the SEC was a factor in 2/3 of the cases in the first 40 years. Since then, what's happened? We have things like private class actions, other things that dominate, and the SEC has receded somewhat at the Supreme Court. So there has been a change. So with that, let's open it up to any questions from the audience, if any, and if not, we'll talk more if you want.
Well, thank you, Adam and Robert. This has been very stimulating, and we do have a number of questions from our audience, and I had a couple of my own I'll kick it off with, but I want to get to all the very good questions that we have in our audience, and you've stimulated a lot of interest, I can assure you. One of your first slides you was a quote from Justice Powell and about his influence on securities law at the court, and he mentions that the SEC has sought to expand. It says generally they've done the regulatory scheme has been useful, but the SEC has sought to expand its reach, and he refers to the history of 10b-5 as an example. What was he referring to generally is the history of 10b-5 there?
So I think part of it was the insider trading that Powell wrote restrictive decisions in Chiarella and Dirks, the Supreme Court's most important securities law decisions to date at that point in time. He wrote those opinions because he thought the SEC was overreaching and should have gone to Congress, right? He did not think that his formulation, which was grounded in a common law approach to fiduciary duty, was appropriately the last word on the question. It mattered that that first case, Chiarella, came to the court was a criminal case. And we had an innovation in the securities law's treatments of insider trading, but it was a revolution that had been created in judicial decisions, that the SEC had started bringing injunctive actions, and then it had migrated over to the Justice Department, bringing criminal cases like the one Chiarella, where the idea of fair notice in the securities law, which takes on a much higher importance in a criminal context, really dominated those decisions. What Powell thought would happen was that he would write these restrictive decisions and that the SEC would lobby Congress for interpretations that were more generous to the policy goals that the SEC was wanting to push with its insider trading regime. And one of the byproducts of seeking broader tools from Congress would have been clarity, and that the rules against insider trading would have been spelled out in a statute that would provide fair notice to participants in the securities industry what the exact boundaries of the securities laws were. That didn't happen for various reasons. There was an initiative to codify insider trading law that didn't actually come to fruition. There have been additional attempts in the time since that have not led to any codification. The SEC has adopted rules around the edges, but has not wanted to deviate from pursuing most of its agenda in insider trading through the courts, which was validated with a big win in the O'Hagan case, which got them most of what the agency wanted in the field of securities law.
But as important as that is, Powell was probably much more influential in stopping implied private rights of action during his period. And we haven't talked much about that, but that's as important for Powell's legacy.
Thank you both for that elaboration. Questions from the audience now. Under today's recusal standards, should those justices who were involved in drafting or advising on the legislation coming before the court have recused themselves?
Douglas did recuse himself, and he kept recusing himself. Douglas ended up having no influence on securities law over the comments on this time of the court, because he recused himself for years for cases that didn't really come before the agency when he was there. He washed his hands with securities. He was on to environmental and constitutional law. He didn't care about securities anymore. So he was the one most affected. The others had, in terms of writing the statute and litigating, by the time they were deciding cases, I don't think we have the recusal questions that we would have today. But there were certainly different standards for recusal then. That part's for sure.
Do you think? I'm sorry. Go ahead, Adam.
The part that hasn't changed is that involvement in writing a statute is not a basis for a recusal then or now. The basis for recusal was actual participation in litigating the case, which caused Jackson and Reed to have to recuse themselves from some cases. Douglas took this very broad interpretation of what counted as recusal from a case, and that's what led to recusals in the 1940s. But they were generally trivial because Roosevelt had been so successful in appointing justices who were favorable to the securities laws in the SEC that losing one or two justices made a difference to the final count, but it didn't make a difference to the result.
But it did delay consideration of the constitutionality of PUCA because they couldn't get a quorum because of the justices having participated and also some having their law firm litigating. So it took a much longer time after Roosevelt appointees had taken hold to get a definitive answer about the constitutionality of PUCA because of recusal. But the ending was not in doubt once the Roosevelt appointees got to the court.
In an era of clever acronyms for statutes, PUCA probably wouldn't pass the test today, but they might have come up with a different acronym for that one. If you compare the confirmation process today from the Roosevelt era, do you think the expertise that Roosevelt looked for and found allies for his appointments, would they withstand the scrutiny that's brought to bear on appointments, nominations to the court today? Would that have been a plus or minus, or do you see similarities or differences? Would he have had a harder time today getting his appointments through a Congress, and the Congress was different then, of course, too. But how do you, what's your take on that?
So this is an area where constitutional law, I think, is the big driver, that the confirmation process was fundamentally reshaped by Roe versus Wade, and confirmation controversies became the battleground for the fight over the constitutional treatment of abortion. And the pattern that emerged after the Bork confirmation fight to replace Lewis Powell in 1987 was that presidents since that time have appointed Court of Appeals judges with a track record of adjudication, but more importantly, avoiding having a track record on major political issues. Roosevelt picked people who were active players in the political arena. No one was more active in the political arena than Hugo Black. And Hugo Black was able to gain confirmation because of senatorial courtesy. He was basically, Roosevelt was basically sticking it to the Southern Democrats for opposing his court packing plan by appointing Hugo Black, who was much more progressive than the other Southern senators of the time. But the standards of senatorial courtesy, they had to confirm Hugo Black no matter what they thought about his ideology. What I think is interesting today is, will confirmation hearings change after the Dobbs decision? It's hard to imagine someone like Lewis Powell being appointed to the court today with no background on any of the major constitutional issues and having that experience as a corporate lawyer. But maybe things are going to change with confirmation hearings now.
But the flip side of that is that all of these of the current, as Adams described, the current pattern, none of these justices have any realistic experience in private practice or in private law or in securities law that's the subject of this book. They all are practice public law, Office of Legal Counsel. That means we can't expect very much about securities other than an attack on the administrative state. And that hasn't been true. I mean, for the first 2/3 of its life, securities law was in sync with general trends in statutory and constitutional interpretation because it was the cutting edge of administrative state. It was the cutting edge of constitutionality. It was the cutting edge even during the 60s. It was the cutting edge when the cutback came in the 70s. You can teach constitutional law through the securities law, but not using the recent decades. It's a much tougher hill to climb.
We have several other questions. I'm afraid we're not going to get to all of them in our time allotted, but let's see how far we can get before I need to conclude. Did William O. Douglas dispute Justice Powell's status as our corporate lawyer, as he was named by Justice Blackmun? Well, he was at Cravath. He worked on corporate reorganizations there. The questioner understands that even late in his judicial career, he alone of the justices could unravel financial facts of an unusually arcane case.
Yeah, I'll say one thing. Excuse me, Adam, but he didn't write many majority opinions. He did late in his career write any number of dissenting opinions in the Powell era. So he definitely had a different opinion. But he didn't care about building majorities the way that Powell did. Adam, go ahead.
So that was they only overlapped for 3 years, Powell and Douglas. Yeah. And Douglas was very busy writing dissenting opinions during that period of time. He was not good at building coalitions, and also maybe not fully committed to the enterprise at that point. He was just basically hanging on to his spot on the Supreme Court.
Yeah. One last question here. You've answered one of the other ones peripherally about Justice Powell's background. The question was, did he serve as an attorney for the U.S. Chamber of Commerce? And Robert, I think you sort of touched on the backgrounds of the justices in previous years. Of the 100, here's another one. Of the 134 cases on the random walk slide, how many remain good law? That is still followed as precedent in the Supreme Court or the Second Circuit? Well, you probably won't have a number.
Yeah,
but
we did measure that. Most of them still are a good law because the early ones are still good because there are different issues, and the later one, the Powell ones, are still good because of the restriction. We'll have to look at that, but I don't have an answer. You have a guess, Adam?
The Supreme Court has never overruled a prior precedent in securities law. I'm
Well,
confident in this answer.
Chenery was a reversal. It wasn't, and O'Hagan could count as a reversal, but we can quibble.
Yeah, that's interpreting reversal broadly. But almost all of those decisions continue to be good law because the Supreme Court is not in the habit of returning to securities laws issues repeatedly. That the small number of securities cases that the court is going to hear, typically going to be one case a year. They sometimes will have decisions that look incremental, which is a sensible approach if you're going to be doing more cases, and then they never come back. And the lower courts have to fend for themselves.
But if the current court were to take a securities case, it would be probably in the major case question doctrine. It would probably be in Chevron. So it may. I'm not sure they'll take a case, but if they do, it'll be the new Supreme Court, not the one we've written about.
Professors Pritchard and Thompson, we want to thank you both very much for taking time today from your busy schedules to join us. It was a very stimulating and engaging, as we see from the number of questions we've had, engaging talk. I'm going to hold up your book again, History of Securities Law in the Supreme Court by Professors Pritchard and Thompson. We encourage you to buy it. You can get it. It's available on the Society's gift, from the Society's gift shop at www.supremecourtgifts.org. And I want to take time to give a special thanks to our Society's Vice President, John Nannis, for alerting us to the publication of this great book. So we were able to host today's program. Thank you, John, for that. And we're glad to carry it in the gift shop. Our next virtual program is a conversation in recognition of Juneteenth. Judge Curtis Collier will be joining me on June 21st at noon to discuss the Ed Johnson case in United States versus Shipp. Registration is open and available on the Society's website at www.supremecourthistory.org. Please join us for what promises to be an enlightening discussion on that topic. A reminder that a survey will go out later today to everyone who registered in advance. Please do respond to it. We want to make these programs as valuable and interesting to you as possible. Thank you very much for joining us today. It is 1 p.m. on the dot, and we are officially adjourned. Thanks so much to Professors Pritchard and Thompson.
Thank you.